Hello and welcome. My name is Charisma Sutherland, and I am your 2024 Canopy Realtor Association, Canopy MLS, and Canopy Housing Foundation President. As a realtor, forms are one of the biggest tools of our trade. We depend on them to stay in compliance with rules and laws to help all parties to the transaction have a clear understanding of the process. Each year, the North Carolina Realtors Forms Committee makes changes to these forms. Some of the changes are small and others have larger impact. This year, some of the forms changes were specifically made to comply with the NAR settlement requirements. We are grateful to have a panel of experts who serve on the Forms Committee to explain the changes and how to correctly use the forms as a part of the post-settlement practice changes. Before we get started with our event today, let's talk about upcoming events. Practice changes are taking effect on Thursday, August 1st. That's this Thursday. Last week, Canopy emailed a special edition of e-headlines, including a video where I reviewed a brief summary of the practice changes. The practice changes involve compensation, pending transactions, buyer agreements, and required disclosures, in addition to the information about the new North Carolina Form 715. We are posting these links in the chat along with brokerrelations.canopyrealtors.com, and I suggest you bookmark for easy access today. Summertime is busy, but I hope you will make time for these upcoming events. Join us for a joint Canopy Realtor Association and Piedmont Regional Realtor Association discussion via Zoom about the South Carolina forms on Friday, August the 9th from 10 to 11:30 a.m. If you are a South Carolina Realtor or a Canopy member with a South Carolina real estate license, you should have received an email from Canopy on how to register. If you did not, please contact Kate Lindsay, that's KLINDSEY at canopyrealtors.com. Next, we have the Greater Charlotte metropolitan area is a hub for business that attracts both domestic and foreign investment, providing a global property marketplace in both residential and commercial real estate. If you are interested in expanding on your global real estate opportunities, then you don't want to miss Canopy's global kickoff event on Thursday, August the 15th from 12:30 to 4 p.m. at the Canopy Realtor Association. Register at canopyrealtors.com. The popular Building Business by Saving Homes foreclosure prevention program will be on Wednesday, August the 21st from 9 a.m. through noon, and it will be via Zoom. This workshop, it educates participants about foreclosure issues in the area, the role of realtors in the foreclosure prevention, and where to find the resources. This course fulfills a core class requirement for Canopy's Workforce Housing Certificate program. The registration is open at canopyreinstitute.com. Now we will have a moment with our sponsors. We appreciate our sponsors, and we hope you enjoy this short video from TR Lawn.
I'm Joe Remsen, president of TR Lawn Realty, a family-owned property management company located in Charlotte, North Carolina, where we've served local investors for over 66 years. During that time, we've been blessed to grow to the 17-county region where we currently have offices in Shelby, Albemarle, and Huntersville. Our professional staff handles all aspects of property management: marketing, leasing, accounting, maintenance. TR Lawn Realty, renting the Carolinas,
one home at a time.
Thank you for that. Now, what you all have been waiting on is we're going to welcome our panelists today. So we'll get started. Today we have Jennifer Frontier. She's our past chair from NC Realtors Forms Committee. Next, we have Amy Baker, chair, the current chair of NC Realtors Forms Committee. John Waite, Martin and Guilford, PLLC, NC Realtors General Counsel. I know you all have a lot of questions, and we are going to try to answer as many as we can. Our panel does have a PowerPoint presentation that will address many of your questions, and we will be dropping helpful links in the chat during the event. If you have a question, you can type it in the Q&A box. Also, note that this presentation is being recorded and you will be able to find it at www.canopyrealtors.com. All right, let's get started. Welcome, panel, and thank you for being here today.
Good morning, everyone. I'm going to get us started by sharing my screen and our presentation today. Let's see. Let's get us in the right mode here. All right, hopefully everything looks good there. Charisma mentioned the Q&A. If we would please keep the Q&A limited to just questions. We've had a couple of just like comments and things like that. I'm going to be going through as we present, kind of clearing things out. And if there's unnecessary things in there, it just makes a little bit more work for us. So we can get to your questions more quickly if we limit that to just questions. So to start off, we've got some helpful links. NC Realtors Legal Q&A. This is a really great place for people to go. The staff there has posted really great things about Form 220, the new Form 715, all kinds of great things. So definitely check that out if you've got more questions. They've done a lot of things lately specific to the NAR settlement. This is what that looks like. So you can see some of the recent ones here, some of them on the forms changes, some of them on compliance, all kinds of really great stuff. So definitely check that out. Also on the NC Realtors YouTube page, John, who will be presenting to us in part today, has done some really great videos on specific forms where he does a deep dive into that form. Some of them are 5 to 20 minutes long, and so he has a lot more time in those to go more specific than what he'll be able to do today. So definitely check out that YouTube channel. Here are some of those videos so you can see what that looks like. And then Canopy has also provided some of the links here. These have already been posted in the chat. We'll likely continue to post those in the chat throughout. But in case you want to take a quick snap with your cell phone of those links, there are some great Canopy resources. In the second link here, the broker relations, a couple of weeks ago, John did a town hall that was focused on North Carolina and South Carolina forms. And that answered a lot of the NAR settlement questions. So definitely check that out for sure. Ooh, I'm going to go back one more. Before we get into the settlement edits, John is going to take over and address these. I just want to preface it by saying we are not going to get way deep into the weeds on the NAR settlement, practice changes, things like that. Today's event is focused specifically on the forms, the changes that we have made in relation to the NAR settlement. But if we focus solely on that and we get too deep into the weeds, we aren't going to get to the other forms changes. Just like every year prior to this NAR settlement, you know, there are tons of forms changes. They're all really important. So if we don't get through this section in, due time, we won't be able to make sure that you're aware of those other really important forms changes. So just know that this section will probably be briefer than you would prefer, but there are tons of other resources that will give you great information. And with that, I will turn it over to John. John, if you'll just give me a cue when you're ready for me to advance to the next slide, I will do that for you.
Sounds good. Thank you, Amy. Appreciate it. I'm going to start off just by saying that the settlement really, as far as edits to the forms that were specific to the settlement, we're really talking about agency agreements. And we don't need to get like super complicated or deep in the weeds about it today. As far as what the settlement really required of the forms changes, it's really two things. One, that there be a disclosure to your client that compensation is negotiable, not set by law, and that it's set by each firm and individual agent. So that's disclosures number one. Number two is just that your agreement with your client in your agency agreement for the amount of compensation you got to get needs to be specific. And if it's going to change, specifically if it's going to be more This happens more on the buyer agent side, but if it's going to be more than what you've agreed to with your client, then your client needs to agree to that in writing. Now, mind you, license law is required for years and years and years for you to have a specific amount of compensation identified in the agency agreement with your client. So if you haven't been doing that before now is the time. It's something that whenever I speak to agents, it's something that I have to remind them to do if they're not doing it already. A range of compensation is not going to work. It hasn't been acceptable under the license law this entire time. The real big difference now is that in addition to the license law, it's also going to be under MLS rules. So all the changes that we're going to look at as far as agency agreements go really go to those two things. Okay. We'll talk about some other MLS rules changes as far as they fit with the forms, but looking at this screen right now, we're looking at the exclusive right to sell, Form 101. You can see that the edits in here are specifically to those two things I just said. There's some relatively simple edits, and that's really what they're meant to do. If you want to change compensation, the easiest way, if you're going to reduce compensation, Form 710, that is the agency agreement amendment form. That's the form that's probably easiest to use for that. And if there's an increase in compensation and your client wants to, if there's additional compensation and your client agrees to that, Form 770 is a good fit for that. Form 770 has always been the disclosure form for additional compensation to keep you in compliance with the license law. And now there's a section on there for your client to sign. There's a small edit to that. That may be later in the presentation, I don't remember. But in any event, that form is not very good if the compensation is being reduced. Like if you're reducing your compensation with your client to match potential cooperative compensation that's out there. But Form 710 will work for both. 770 if you're looking for additional. All right, I'm ready for the next slide. All right, here, this was a CYA that was added to the form even before the settlement changes came out, and by the way, before we get too deep into this presentation, it's not like, Jennifer and Amy and I went up on a mountain and then came down with stone tablets for these forms changes for you guys. The forms changes are a result of a lot of hours of work. It is a year-long process by a lot of volunteers. There's about 25 people on the forms committee, and they are people that work tirelessly to make sure that the forms reflect your industry and reflect risk management issues that we may or may not even know about. And this was one of those examples. I will say this year, the forms committee is going to be extremely busy. It was an extremely busy year last year. And honestly, I don't know how they survived. We were talking about volunteers here that they put in a lot of hours. And even when they thought the form cycle was done, it wasn't done, because then they settled the case in March and we had to do a lot of these edits after that. This wasn't one of them. This on the screen was a CYA forms committee came up with even before the settlement. So kudos to them for having a crystal ball and for figuring that out. There probably will be some changes to this section through the coming year as the forms committee continues to be responsive to how you guys respond to the MLS changes in industry practice and things of that nature. In any event, have your seller initial this so that they is a CYA to make sure that they understand cooperative compensation is not required. I will also mention, because this will be in a Q&A from NC Realtors coming out Monday, I believe, that if your seller is not authorized cooperative compensation, then this section, paragraph 8, it just means it'll be blank. Like there won't be anything in there. So we've been getting that question. One of the things our law firm does for NC Realtors is answer the legal hotline. That's one of the questions we've been getting about this form in particular, Form 101. So while I have you guys, while I have a captive audience, I will cover the hotline question. Maybe I can head off a couple of emails that way. All right, I'm ready. Next slide. All right, in the buyer agency agreement, like I said before, these edits are really for two things. Obviously, additional compensation is a much more common thing, or was, when the MLS still offered cooperative compensation, still had offers of cooperative compensation in there. With those coming out, that is going to change. There's been some stressing of the fact that, do not put NA 0 or range of compensation. Again, that is traditionally been the rule of the license law and now also MLS rule going forward. The other edits on here are really to make it clear that if there's additional compensation over and above what your client has agreed to in B there, then they have to agree to that separately in writing. All right. I'm ready. Okay. This is also in the exclusive buyer agency agreement form 201. Moving on down, you can see that there's an initial line here so that the buyer can understand and agree to how the money flows in the transaction. I think the forms committee rightly felt that, this was something that, in some of these other cases that existed out there, in the antitrust context, not the one in Missouri that got settled necessarily, but in some other ones, there's a recognition that there were some allegations that the buyers just don't understand how the money moves in the transaction. So what this paragraph is meant to do is for them to initial and understand that they do, in fact, understand how the money moves in the transaction. Make sure you take time to talk to your client about it too, and make sure that they understand that especially if there's cooperative compensation, this is how it's going to work. And if there's not cooperative compensation, then hopefully you're having a detailed discussion with them on the front end about what the value of your services are and what they'll have to pay. Okay, next slide. This agency agreement here, if you're not familiar with this, this is something that you may be using a lot over the coming weeks. This is the non-exclusive buyer agency agreement. Some firms use it pretty regularly, other firms do not. If you need a simple agreement with a buyer to be able to tour a home, and mind you, let's just back up a little bit. MLS rules are going to require you to have a written agreement with the buyer prior to touring a home. Working with a buyer is exactly what it sounds like. You got to be working with the buyer. If you're the listing agent, or if you're a seller sub-agent, or, in other words, if the buyer is unrepresented, then you don't need a written buyer agreement, okay? It's not going to be required under your MLS rules. But if you are working with a buyer and you need some kind of simple agreement to be able to, show them a home, this is a good agreement to do that. It is not, you can see right there on the screen that the agreement does not obligate the buyer to pay. So it is dependent on you working out cooperative compensation, potentially to get paid. It is in compliance with the MLS rules because it's not totally dependent on cooperative compensation. In other words, you still have to put a specific amount that you expect to receive from the seller. You're not going to insert in that line right there, whatever the seller's offering, that's what I'm going to get paid, okay? That is not going to fly with the license law. That's not going to fly with your MLS rules, okay? It's not going to be in compliance. A specific dollar amount of some kind, so some way. On the other form, it said, don't do a range of compensation. But one thing that agents have been bringing up is that, let's say that there's a dollar range of like house prices. It'll be a certain amount for this amount, certain amount, for this price range of house, it'll be this amount. I think that kind of sliding scale is fine as long as the amount of your compensation is specific and, and can be, factored into a specific dollar amount. Okay. So on this line here, to stay in MLS compliance, it's okay to say where the money is coming from, how it will be paid. That is separate and different. What you need to have is an agreement with, in order to be in compliance with the written buyer agreement, it's really got to have two things. One, what you expect to be paid, and two, that commissions are negotiable, not set by law, et cetera. This form has been edited for those two things. And the Q&A that just came out Monday this past week, I'm not going to go into the Q&A in depth, but one of the things I've been telling agents on the hotline is that this form is essentially a written confirmation of what oral buyer agency is. Oral buyer agency still exists. It is still part of the license law. You cannot tour a home anymore under oral buyer agency. But if you sign something like this, now mind you, you don't see the full form on here, but the actual text is 3 pages. Other than that, it's a wire fraud warning and then signatures. Okay, this is not a complicated form to go through with your client. So if your firm has already created a written buyer agreement, that's fine. If you need one, this one will work. And it would be in compliance with both the license law and the rules. And you can see the edits on the screen have been done to make sure that it's in compliance with the new MLS rules going forward. Okay. All right. Let's see. Yeah, okay. Form 715, this form came out a couple of weeks ago. This is to help you bring old forms copyrighted 2023 and earlier into compliance. There's really 2 things in here. Again, the 2 things I've already covered are in paragraph 1 And then paragraph 2 says everything else, including any addenda to your agency agreement, will continue to be full force in effect. So there's 2 ways to bring your agency agreements into compliance. Your old ones, you can do 715, or you can just execute a new one on one of the new agency forms. So if you want a simple 1-pager, this is an easy way to do it. One of the common questions I've been getting on this form is, what if my client doesn't sign? So in the Q&A that came out on this, and it's located where Amy pointed out earlier, if your client refuses to sign, mark on it, they refuse to sign, just like on the WWREA. And then if there's a situation that comes up that involves additional compensation, feel free to give a call to the NC Realtors legal hotline, and we'll be able to walk you through that process. That should be handled on more of a case-by-case basis. Well, hopefully, these 2 things benefit your clients. So hopefully you're not going to have too many people refusing to sign it. But if you do, it's something that we can walk you through when that time comes. Okay. All right, here we have Form 220. And I'm going to slow down just a little bit, just because there's been so many questions on this form and so many different ways that people want to use this form. And I will say this, there's just not one right way to use this form, okay? It is meant to be a Swiss Army knife. And so just, understand that. There's not going to be one right way to use this or anything like that. Let's start with something just very, very basic, okay? Agreements as to compensation between agents is not required to be in writing, okay? It's just not. An oral agreement as to compensation is enforceable as between agents, always has been. So that's not different. So for example, if you were just talking to an agent, you came up with you agreed orally to some sort of referral agreement or, something like that, compensation sharing, that would be enforceable. The problem is that how do you prove that, right? Like if somebody doesn't do what you said, what you agreed to, then what do? You have to take them to court or arbitration or whatever, right? Written contracts do not prevent people from, doing things that they should not do. That's not the goal of contracts. What they are is a method of accountability if somebody agrees to something and then doesn't want to do it later, okay? And I can tell you from, in private practice, litigating NC Realtors forms, they are extremely effective in court at proving, we agreed to this and the other side is not doing what they're supposed to be doing. And so I'm entitled to damages. I've enforced agency agreements. I've enforced contracts. All these, a lot of these forms I've actually litigated in court. They hold up very well. That's what this is for, okay? This is meant to be just a written confirmation of cooperative compensation between either the seller and the buyer agent or the listing firm and the buyer agent. And then in best practice, everybody needs to sign, just because, under the license law, clients need to know, how commissions are being split, how it's being spent. And especially in the case of additional compensation, if you're on the buyer agent side, then that means that you're going to want your client to agree in writing to any additional compensation. So this form could work for that too, in addition to Form 710 and Form 770, which we covered earlier. So just understand that this agreement is not meant to just fit one square. Okay, so let's talk about paragraph 1 really quick, and kind of go from there. As far as check only one, there's a reason for that. You only want one party or the other to be obligated to make it clear who's paying in the transaction. If you check both, then it's kind of like, all right, well, who's paying what? Probably most of the time, it's going to be the listing agent checkbox that you're going to check. And the reason for that is this. If you sit down with the seller and the seller agrees to cooperative compensation, it seems like, at least for right now, a lot of sellers are still agreeing to offer in cooperative compensation somehow, some way. Okay. That's fine. That may change. I'm just saying that's where things seem to be right now. If the sellers authorize cooperative compensation in the listing agreement, then that means if they filled out paragraph 8 in Form 101, and that means the listing firm is going to share compensation pursuant to paragraph 8 in the listing agreement. Okay. So that means in the checkbox, listing firm And then you would go through, fill it out, and all 4 people sign to make sure everybody's on the same page about how cooperative compensation is being shared. Okay, so that's one scenario. Second scenario would be this, that the listing agent sits down with the seller. The seller's like, I'm not offering anything. Like, I'm just not doing it. Okay, fine. You fill out Form 101, and the listing firm agrees to its compensation in paragraph 7 of Form 101. Paragraph 8 is going to be blank. There won't be any of those check boxes. There's no authorization for any cooperative compensation. That's paragraph 8. Okay. And then the seller gets an offer later where the buyer agent has conditioned the offer on cooperative compensation because their buyers told them to do that. Okay. In that instance, if the seller's agreeable, then instead of the listing agent having to go back, change their agency agreement and all these other things with the seller, you could check the seller box, and then the seller can agree to pay cooperative compensation to the buyer agent. There may be some rare cases where the listing firm offers some cooperative compensation, and then the seller also does. So there could be times where in a given transaction you would have 2 Form 220s, one with the seller and one with the listing agent. They're both be enforceable. But the reason the form says check only one is to make it clear as to this contract, who is agreeing to pay, right? Because you look at that first paragraph there, seller or listing firm agrees to pay, all right? And so you really only want to pick one or the other depending on those scenarios. If you got something else that's real crazy, reach out to the legal hotline. But hopefully that gives you sort of the framework of how usually this is going to be filled out. So then moving on down to paragraph 2, there's a language here about when the commission is earned and when it's due and payable. So that's meant to mirror kind of how the agency agreements work too. Understand that it may well be that the fee is earned but never becomes payable, just like in agency agreements, right? As soon as your client goes under contract, you've earned your commission, but it may never become payable if the buyer terminates during the due diligence period, right? Same thing with this. It may be earned when the contract is signed, but it may not be payable ever if there's no closing, okay? Or maybe will become payable at closing. And then finally, paragraph 3, it has term, effectiveness, expiration. On the expiration date, what I would recommend is leaving that blank at least at first, and then putting a date in there that's 1 to 2 months after the proposed closing date and any given offer to purchase. So give yourself some cushion. But the goal with the termination date is that it's not just hanging out there forever, okay? That there's some kind of end date to it, much like the referral agreement, where you don't necessarily want these sorts of contracts just hanging out there forever. You want some kind of end date to happen, okay? Mind you, you can see in that last part in paragraph 3, if the fee's been earned, then it's going to keep going, okay? So it's just because the date passes or closing passes or whatever, if the fee's earned, then that's I wouldn't, you don't have to worry about that, okay? It'll continue to be enforced in effect until there's a closing or the contract is terminated somehow. So all right, finally, on this form, there's a Q&A that came out, and there's some confusion that I want to address while I have you guys a captive audience. There's some guidance in an NC Realtors Q&A that said, hey, if your seller's going to sign one of these, then don't post it on your website, okay? I want to stress that is just a safe harbor recommendation, okay? If listing firms want to have their client, their seller client sign one of these, and they want to post that signed, Form 220 on their website, they can do that, okay? It's not like a rule or law saying that the listing firm cannot do that. The reason that safe harbor guidance is in that Q&A is because a lot of this happens somewhat regularly when it comes to due diligence repair requests, and I expect it could also happen with Form 220. So that's where the guidance is coming from. And that situation is specifically this, where the buyer will send over a due diligence repair request. There's a bunch of negotiations, people get frustrated, and then maybe the seller will come back and sign the original after there's been a bunch of negotiations. Yeah, no. When an offer is sent and then a counter offer is sent from the other side, that terminates the original offer, right? Like you guys deal with this every day when it comes to the offer and purchase and contract, but the same rules still apply to, due diligence repair request, which is a separate agreement. And also this Form 220, which would be a separate agreement, okay? So just understand that you can do that, but in order to prevent potential, just drama, that's why the recommendation was don't have a sign 220 just hanging out there on your website. But if you feel confident as listing firm, and I've talked to listing agents who have have a system in place for this, they feel confident, that's fine. You can do what is best for you. But I just want to make sure that that's really clear. There was a little bit of confusion with that. We may tweak that language in the Q&A to make it sound less like you guys are going to end up in realtor jail if you do something like that. It's really just like a sort of best practice to try and cut down on drama and things like that. Okay, I'm ready for the next slide. Yeah. Well, we completely gutted and rewrote Form 220. So the old guidelines are not really applicable. Amy has a very full plate as forms chair this year. And yeah, she's going to spend a lot of volunteer hours figuring out new guidelines for this and guidelines for some of the other forms. So we'll be working on that this coming cycle. Okay. All right, Form 770. As I discussed earlier, this disclosure compensation, it's traditionally been used just to, you would send it, to a client if there was additional compensation in the transaction, other than what you agreed to in the agency agreement. Now there is the client's not just acknowledging it, they're also consenting to it. So that language has been added to make it so that, you don't have to go back and change your agency agreement or anything like that. If there's additional compensation, then 770 will work, 710 will work, and potentially 220 if you actually entering into a cooperative compensation agreement with the listing agent or the seller. Okay.
All right, this is me. We're not going to talk about some of the changes we made to the offer to purchase and contract this year. One of the changes that we made is it's section 1I, so it's on page 2 near the bottom. Seller or seller's agent may direct buyer in writing to make the due diligence payable to a party other than seller. Seller means the names that are on the beginning of the contract. Husband and wife, son and parents, LLC, whatever you have your seller, that is the seller. So if it's a husband and wife getting a divorce, the seller can direct the buyer to make it to one of the specific parties. If it's buyers that aren't related in any way, when sellers have different bank accounts, it makes it difficult to deposit due diligence checks if they're written to both parties. So this allows the seller to direct where they want the due diligence fee to be paid so that the buyer's agent can direct the buyer where to write the check. And I'll make it easy for everybody going forward. Instead of writing all the sellers' names on the check, it would work great for an estate where there's multiple names and it's only going to be one person. 1031 exchange, relocation. There's lots of instances where it only needs to be to one specific party. Okay. Next. So we made a change on the, and this isn't me, sorry.
Sorry, and all of my clicking and answering questions, things are getting a little crazy. Go on back. Okay, here we go. I'm up for number 19. So agents were asking us for an option for the due diligence date. So you submit an offer, especially in multiple offer situations, you might not know when you're going to get a response, and you don't necessarily want that seller review, response time to eat into your due diligence period. So to make sure that that was executed correctly, the Forms Committee did decide this year to break that up and offer 2 options. So now an agent can either put in a specific end date, which is what we had prior, or a number of days, and then refer later in the contract as to how that number of days should be correctly calculated.
All right, moving on to governmental compliance. These edits are really just technical edits. I think they are things that are already in the existing contract. So if you have a contract that's on the previous version of 2T, I think these things are already implied in there. I think the Forms Committee rightly saw that it would be a good idea to insert these things explicitly. But it's really two things, which is, if the buyer has to establish that the violation exists, the burden is not on the seller to prove a negative that no violation exists. Okay, that's number one. Their duty is to disclose what they know on the front end if they want the protection of not having the buyer come and establish some kind of governmental violation later. Okay. And number two is that the buyer can't just sit on that information all the way up to closing and then spring it on the seller last minute to try and create, some sort of, issue. So two things, the buyer has to establish a violation and they got to promptly notify the seller if they want to take advantage of this paragraph. Now, mind you, the Forms Committee, last cycle spent a lot of time debating this. And the goal of it was really to put the buyer on a little bit equal footing, in situations when, and this situation actually happened, where, the seller advertises the house is on septic and that septic is a hole in the backyard. Okay. It was meant to give buyers an out where the seller's made, some kind of either failed to disclose a serious permitting issue or where they've made a misrepresentation even, and to not put them in a position where, well, do I take this house and, cross my fingers or take on this huge liability, or, do I, potentially lose my due diligence fee and get in litigation with the seller to try and get it back because, they really should disclose this very serious thing. Okay. And so the Forms Committee really looked and established a subcommittee to make sure that this paragraph was operating as intended. And the feedback on it was pretty good. So, understand the Forms Committee, they're always receiving input and feedback on even things that have been done before. And they're always very receptive to that. It doesn't mean they're going to agree with you necessarily, but I can tell you that they take your input very seriously. They did look at this, given what a substantial change it was in 2T. They dedicated a subcommittee to look at that and make sure it was working as intended. And then as part of that subcommittee, they came out with this change. So I thought it was a really good edit. And there we go. And then, in Form 2G, which is the guidelines to the offer to purchase, which will be looked at this coming cycle, I hope. We'll see. I mean, you guys might be keeping us pretty busy with some other things. I'm not sure yet. We're going to try to get to some guidelines. In any event, you can see the guidelines here also make it clear, reiterating the two things that were added to the paragraph. All right.
Okay, this is the guideline. So this is Form 2G that goes along with 2T, the offer to purchase a contract. This is under section 2C, and this has much more information. It is very specific. So these are instructions that you can give to your seller. It is extremely important that they unpair smart devices and delete their personal data as required in this paragraph. It's very seriously worded, but it is true that if they do not unpair, do not remove their data, and they can continue to watch the new buyer, it can expose themselves to criminal or civil liability. So they should not do that, and you really need to make sure that they are unpairing. And more with everything being electronic and on smart devices, you need to make sure that everything is unpaired and they've removed all their information, reset it back to factory settings or whatever the instructions are to reset that particular device back to where the current seller cannot access anymore.
Oh, I keep muting myself. I don't want y'all to hear me typing while I'm answering questions. We're moving into the exclusive right to sell. Some of these changes were made in both the exclusive right to sell and also in the vacant lot land. And so if that's the case, they have been noted on those particular slides. And let's see, this one. Oh, so relating to the payment of the due diligence fee to somebody else. So we added this into the exclusive right to sell listing agreement so that it spurs a conversation with the listing agent and the seller. So when you sit down with your seller, you're signing a listing agreement. Hey, seller, Mr. and Mrs. Seller, whoever it is, right? How is this transaction going to go? Once the due diligence fee is paid, how should that be paid? Should it be paid to the two individuals sitting in front of me, to one of the individuals? Is it a 1031 exchange that needs to be paid to an intermediary, a relocation company? Does it need to be held by a closing attorney? Is there something else? And there's a place now in the listing agreement where the seller can give that direction so that when a buyer agent presents an offer and then says, hey, who should we make the due diligence check out to? How should we get it to you? The listing agent already has that information because the conversation has already been had.
We had lots and lots of conversations this year about flood hazards, wetlands, flood areas. And we've realized that across the state, whether you're in the mountains, the coast, here in the Piedmont area, they're called a myriad of different things, and there's no way to have all of them disclosed. So we kind of changed this language, and a lot of it had to do with the conversation we had with the vacant land disclosure, so that now it says flood hazard, wetlands, and flood insurance disclosure. So we changed the way it works. It's just a yes or no box, and we took out the negative. So the property is located partly or entirely within a designated federal, state, or local flood or hazard area. Yes or no? The property is affected by other water or riparian issues such as creeks, buffers, or wetlands. Again, those are just a few examples. There are so many different water and riparian issues and names for them across the state that we couldn't possibly put them all in there. So if it's something else, if it's a yes, then you can list what it is in the detail line. Again, yes or no, the seller does not currently maintain flood insurance on the property. Yes or no. So that's what that change has to do with. And it's also in the right to sell listing agreement for vacant lot. So this line is also in the listing agreement, and it's to help listing
Jennifer, for
agents.
some reason, we lost your audio. You're not muted though.
I'm not muted.
Oh, you're back. Okay, go ahead.
Okay, can you hear me? So this form is also on the right to sell listing agreement, and it's to prompt the conversation with the seller if they are working with a relocation company. There's relocation companies have lots of rules and guidelines and different ways to handle sales, and it is much better for the listing agent to know upfront if there is a relocation company involved. The edit was also made in the lot land form as well. Tend to make the same changes across all the versions of forms when we make a change in one form.
And it might be me who's actually having some issues. I'm getting a notice that my internet connection is unstable. So Jennifer, take over just on the in case.
Okay.
But we are going to get into other form edits. So prior slides have been kind of grouped by like big sections. These are some other forms that sort of individual changes that we wanted to highlight to you. So we will start with adding a buyer to the contract on the agreement to amend with John.
Yeah, this edit is meant to make it easy to add an additional buyer. And I think Forms Committee will be looking this coming cycle to potentially expand these sorts of check boxes in this amendment. Not to say it'll necessarily happen, but I think they're looking to explore it so that it's just easier to change parties, especially when a lender has an issue. You need to add somebody or take somebody off. Hopefully we'll be able to look at that. This form has to go also through another committee called the Joint Forms Task Force, which is a committee made of lawyers at the Bar Association who serve on the real property section, as well as some realtors. So hopefully we'll be able to come up with some other good changes. But if you guys have a situation where you need to add a buyer, for lender purposes to a contract. There's not an easy way to do it. They just jump right in the shoes of where everybody's at and keep on trucking.
So we have an overview of standard contract, just like we have guidelines for how to fill out various contracts and forms. We have an overview of standard contract form. There is a Spanish version available as well. And we cleaned this up quite a bit this year. We took some things out. We added some things with the changes that we made to the to 2T and the other versions of the contracts. And it should be easier to understand and use. So if you think about, but this form gets missed, not everybody knows we have this form. If you think about the guidelines as a form to help you fill out the contract, this is the form that you could give to your client so that they understand, and when is the initial earnest money due? What is earnest money? What is due diligence fee? It just talks about different things throughout the contract terminology and how the contract flows and closing. So this is a great form to use for your clients, and we have made it more user-friendly, and we hope that you use it. So as John was saying, we did a lot of changes with the settlement language, but that didn't happen until later in the year. Most of the year we spent creating new forms, and we did some major overhauls to forms, and 800T was one of those major overhauls. The form really wasn't great. It didn't kind of follow the flow of how a construction process works. So we did make some major edits to it. A few of those edits are the following. So plans and specifications was in there, but we've added that all plans and specifications must be listed below with copies attached as exhibits. So those plans and specifications are then part of the contract. We've listed some site plans, subject field, well locations, house plans, elevations, general finish and fixtures, landscaping and hardscaping plans, schedule of allowances, other. And if there's something that we haven't listed in here that is part of a build somewhere in the state, then it can be listed in other. Next slide, Amy. Sorry. Okay, so in the old version, it was not construction fees. It was building deposit, and we've changed that to construction fees. So construction fees is the terminology that will be used throughout, and it's identified in this first paragraph when it should be paid within 10 days following a triggering event. The triggering event section was the dollar amount, triggering event, and blank lines for a date and what the event was. And it was up to you to put what the date was and what the triggering event was. So to make it easier, we put in some specific dates that are part of a building process to make it easier, and what the dollar amounts were and what that triggering event would be so that it is correct from contract. And the next slide. So this is to help have a specific date. So the builder can't keep changing dates, extending dates. Substantial completion is now a paragraph in here. Completion of the construction of the dwelling in accordance with the plans and specs. And then give some instructions: is habitable and broom clean. A certificate of occupancy has been issued by the appropriate government authority, and any punch list items have been corrected. So substantial completion dates shall occur on or before, and then you put the date in when you're writing the contract. Subject to any permitted delays that are part of the contract. There are other dates in the contract that rely on this. Settlement date, for example, is 14 days after substantial completion date. So that date's really important, that it's agreed upon upfront, and that you get the builder to stick to that date, barring a hurricane or some other unforeseeable event that then you would negotiate to change that. But this should give some relief to the buyer so that that date doesn't keep moving in the forward as the builder gets behind. And then the next one is the guideline. So because we had so much on our plates this year, We did not get a chance to correct the guideline. The guideline that was in place was for the original form. And so we just temporarily suspended it so it wouldn't cause confusion. We will correct that this next cycle, and then you will see a new 800G guideline for 800T comes out of the next form cycle. As I said previously, we did create some new forms. This is one of the forms that we created. This is just more of a guideline for you. It's not a form that has to be signed by anybody. What we have heard from the attorneys on joint forms and from attorneys in general is that we do a pretty bad job with estates. By the time it gets to the closing table, they have to try to correct things. And in many cases, it cannot close because the seller is either the wrong seller. Some sellers should be on or not. Spouses of sellers are heirs are not on the offer to purchase. So this is just a flow chart for you to use. Couple important things. Number one, you need to have an attorney help you with this, whether it's the attorney for the sellers for the estate. If they don't have their own, go to an attorney that you rely on, because these are very complicated and there's lots of different factors depending on the situation. So something that's in bold in the warning box: deceased people cannot own real property. The attorneys, all this information came from the attorneys. They want us to stress this. Do not put the name of the person who has passed away. They cannot own property. Do not put the state of that person. So go through the flow chart, figure out where your particular situation is, and we can't say more than enough. Get an attorney, get an attorney, get an attorney to help you. There is a second page to this that has a lot of other factors. If there's one of the heirs is a minor, that gets even more complicated because the guardianship has to be established. So these are complicated, and we want to do a better job with them. We want to sell more of these properties, and we want to actually be able to close on them. So next form.
Oh no, this one's me. I'm excited about this one, like serious dork level excited. So this is our new closing guidelines form. So it's just a kind of a one-stop shop form that you can send out to your sellers and say, hey, look, this is how you prep for closing. Here are your contractual obligations. Here's everything that you should do to prep for closing all in one place. Like what fixtures stay, unpairing their Ring doorbell, when do they cancel their insurance? Do they need to keep the lawn up through closing? All of that is here. We had some really, really great committee members who kind of already had something like this that they had developed themselves. And we sort of put all of ours together, picked out our favorites, and it's a combination of kind of all of our best practices. So we really hope you guys like this new form.
Okay, vacant land disclosure is another form that we created from scratch. We had been getting requests for a form like this from agents across the state who sell a lot of land. We had all these forms. We had separate task force for within the forms committee, so we had lots of extra meetings. We had lots of conversations about everything that's involved in land. So if you sell land, please pull it up and look at it. If you ever think about selling land, please pull it up and look at it. I'm pulling mine up in front of me. The water rights, the septic. I'm trying to think what else is in here. Agriculture, timber, mineral aspects, environmental aspects, utilities. There's so much information on here that is not always on the regular disclosure because there's more involved when it's vacant land. Any of the physical aspects, draining, grading, grave sites, septic systems, I had already said. So there's a lot on here. So you want to have your seller fill it out. It's not part of the statute, so you could go through it with them and they still have the same rights. So it should work the same as our post does now. They can say yes, they can say no, they can say no representation. There's it's a lot of detail. So that's why I said, before you do that, I would go review it. Before you go out and talk to seller, I would review it. If you're thinking about ever selling land, I would review it. If you have the opportunity to take a listing for land and you've never listed it before, I would review it and decide, oh, there's a lot of, I don't even know what any of this is. Should I list land? So hopefully this is helpful, a worksheet for you to list and to get as much information from the sellers as possible when you fill this out. You want to have your sellers fill it out the same way. You can post it in MLS as you did before with the other disclosures. And we hope that it will be a helpful tool when you have a buyer or a seller who are doing a lot or vacant land. Next slide. So because of this form, we added some new language to the Form 12T, the vacant lot land offer to purchase and contract, so that the buyer can check if they have received Form 142, if they have not received Form 142, and then this says that they have the right to terminate or withdraw this contract without penalty, including a refund of due diligence, if they have not received the form by the end of the third calendar day following the effective date. So it's meant to work the same way that the residential property disclosure. And then
it's back to me. Whew, my fingers are tired, y'all. So I've already said it a couple times in the chat, but if you ever have suggestions, questions, comments, concerns, really anything for the Forms Committee, I have put on the screen the Forms Committee email address. That comes into our staff liaison. She triages everything, and a lot of them, as chair this year, come directly to me. I get emails daily of specific questions, comments, concerns, how the forms work, not necessarily how they work, that would be better directed to the legal hotline, but hey, this says blah, 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 and it's just not quite working in practice. Could you guys take a look at that? Absolutely email that to that email address. We also look at things like how the forms are functioning in the various software platforms, for example, SkySlope and Zip Forms. So if you're working with the forms in Zip Forms and like you type something in a field and it's just behaving weird, it's connecting funny, or it's not connecting properly, that's a great place to send that to as well. I get a lot of those. I can pop into Zip Forms and triage it, and then we can get with our Zip Forms team to correct those sorts of things.
And can I just say that earlier, Courtney put in the chat the phone number for the NCR legal hotline. So if there's how a form should be used or a legal question, then that can go to the legal hotline number that Courtney put in the chat. And Don mans that legal hotline. So he hears from, yeah, so it's really the legal hotline number. So forms, questions, or corrections and things go to the forms. And how to use forms or legal questions, that goes to the legal hotline.
And then, dare I ask, any questions? So
There are lots of questions about 715 that I was reading.
Yeah, there's a lot. And so, first of all, I've seen a lot of questions in the chat about the new residential property disclosure. I'll just answer that as a blanket here. That is not one of NC Realtor's forms. So the residential property disclosure is dictated by the North Carolina Real Estate Commission and is actually governed by state law. We have no power over that form. We were not involved in the edits on that form. We received it just like you guys did. So any questions, comments, or concerns about that form specifically need to go to the North Carolina Real Estate Commission. We cannot address those here because it's just not one of our forms.
And the same with the working with real estate agents disclosures. Those come from the Real Estate Commission as well.
That's right. Yep. No, we don't have purview over those. Jennifer, you can help me answer this one. I've seen a couple of people ask questions about forms in Spanish. So I'll answer the question. You jump in as our past chair and tell me if I have spoken or not said it correctly. Translation is very, very, very expensive. The translation process is very detailed, very tedious, and there is a charge per word, if I remember correctly.
Yes.
So it is just a budgetary limitation. And also whenever a form is translated, right? We sit in a room and we, down to the comma, the word choice. I mean, we may take 15 minutes in these committee meetings and debate a single word. So when that is then translated into another language, things can get lost in translation. And so that would create an entirely different process where we would need native speakers or very competent speakers in that language to make sure that the meaning of a passage has remained in that new language. Then we could also get into, if we translate into one language, do we translate into others? So for a myriad of reasons, we have translated some very specific limited forms, more customer-facing forms into Spanish at this time, but no others have been done. And I don't know of any plans to do any others in the near future.
I would just add that sometimes we do not make these decisions on our own. For example, when I talked about the estate worksheet, we got a lot of help and assistance with that from the attorneys and joint forums. And we reach out to the attorneys and joint firms quite a bit. In this particular case, we have more than once in a forum cycle, so multiple years, have gone out to committees like the NTRYPM committee, the Diversity and Inclusion Committee, and the Risk Management Committee. And we've talked to them and asked them to weigh in on this issue as well. And so just from a diversity and inclusion perspective, yes, Spanish is probably the second most spoken language in the state. And is it an issue because we are not being inclusive of more languages? We heard back from other Spanish speaking members of those committees that there are so many different dialects from so many different countries that there's not a perfect way to translate this into Spanish. The money issue Amy talked about is extremely expensive per form. So every time we make these changes, we have to have the whole form done again. And then risk management was concerned that would the form be used from agents who speak absolutely no Spanish whatsoever. So you don't speak any Spanish, you're putting it in front of somebody and saying, here, sign this. I don't know how to tell you what it says. Just sign it. Or worse, you have one of their minor children have them sign it. And so risk management felt like that is not a good purpose of having forms written in another language. In addition, one party of that transaction might speak another language, but the lender or the other parties in that transaction may not. So that's why it stays in English. Now, we did translate the overview because the overview is a form that you can give to them so they can read in their language, they can get more familiar with the terms and understand it a little bit better so that someone can go through the contract with them that speak Spanish and help them understand what the contract says, if that helps at all.
Thanks, Jennifer. I'm seeing a couple of questions about unpairing of devices. So I'll just speak to that just a little bit so I can clear some of those questions out. So we're a technology world now, right? So many sellers have their thermostat and their Ring camera and their whatever else all connected on their phone and all that. Well, after closing, a couple of things can happen if the seller doesn't unpair those. So they need to go back into their Ring app and say, I don't own that house anymore. Take that device off of my phone. So first of all, a seller shouldn't be able to see the Ring camera at a home that they no longer own. They shouldn't be able to control the thermostat at a home they no longer own, right? There's just privacy and legal issues there. So they need to unpair for that reason. But then the buyer also can't set up that Ring device on their cell phone so that they can control it until the seller turns off their control. So it's just one more place where we are reminding sellers and listing agents that as of the closing day, the seller needs to disconnect those services so that they no longer have access to them and so that the buyer can set up their access.
And it's becoming more and more devices, lights, hubs, a whole house hubs, thermostats, appliances. There's more and more in a home that people are controlling with their phone. And so they are paired to those home devices through their phone. And that all needs to be unpair and disconnect, I would say, is the same thing.
Yeah, not to step on Charisma's toes, but if it's all right with Charisma, I'll continue going with some of the kind of question themes I've seen. I've had, thanks, Charisma. I've seen quite a few asking about the new vacant land disclosure. So John, if you could jump in, is it required? I've seen, is it required for an estate? Can you speak to that a little bit?
Yeah, so the new vacant land disclosure is not, it's not required by statute. It is required by the contract. So there's not an exception for estates or anything like that. You know, it would be something where if it is an estate situation, somebody can fill it out, check no representation, and then, you know, fill the square and move on. Just otherwise, just understand that the penalty for not filling out the vacant land disclosure in the contract is the same as it is for the RPOs and the WOG, and that is that essentially the buyer gets a very small 3-day window after the effective date to terminate. And then if they do, they would potentially have a claim to get their due diligence fee back in addition to the earnest money. So if the seller is willing to accept that risk, then, you know, it's not something, if you got a seller who really doesn't want to fill out the disclosures, they're willing to accept that risk, then it's not something you have to, you know, get an argument with them about. So the RPOs and MOGs are required by law. But the vacant land disclosure is just required by contract. It is required, but only by contract.
Someone asked a question about the exemptions in the statute.
The exemptions in the RPOD statute?
Well, the exemptions apply.
No, the statutes just don't apply.
And then the other question I saw, there's a bunch of them in here, is the new form 715. If an agent already has a client that is under contract and they have signed a buyer agency agreement on the 2023 version of the form, do they need to get 715 signed prior to closing, or do they not need to do that because they're already under contract?
It doesn't matter what phase your transaction is in. The agency agreements simply need to be brought into compliance via, you know, because of the MLS rules go into effect. So whether your client is under contract, you know, whatever, doesn't matter. If you got an agency agreement that's, you know, currently in effect, it just needs to be brought into compliance.
So that's either a new agency agreement or 715.
Right.
And I've seen quite a few questions about South Carolina forms. We are the North Carolina Forms Committee. We have no relation whatsoever to South Carolina. Some of us are South Carolina licensed agents, but we do not participate with their forms. We can't speak to their changes or their form cycle or anything like that. So today's meeting is limited only to North Carolina. That hits the highlights that I saw. Jennifer or Charisma, did you see any others that we have not answered that were kind of a common theme?
I'm going to come back and I just want to remind everyone the South Carolina Forums Hot Topic will be on August 9th. So please do not forget to register for that also. I'm seeing some common themes about the 770 forms. Really how to use it correctly has been used to disclose compensation in addition to what you're receiving. So they just want to know if the seller is offering additional compensation or if they're not receiving an additional amount. They want a little bit clarification on the 770 form.
Well, like I said, I mean, if there's additional compensation offered by the seller that's over and above what's in the buyer agency agreement, you can use 770, you can use 710 or 220. Like as long as the buyer is signing something, all three of those forms, you know, are available to be used for the buyer to sign something to indicate that they are, you know, consenting to the additional compensation over and above what's in the buyer agency agreement. So I saw that question a couple of times, but a lot of the questions in here, at least in the chat that I see, I already answered at some point, or Jennifer and Amy already answered too. So I was sort of skipping over those.
Okay. So
one thing that there's a question in here that we're not going to address today. It is possible to make an offer to purchase that is conditional on the listing agent also agreeing to cooperative compensation. There's a Q&A about this. that goes into a lot of detail called Navigating Cooperative Compensation in Compliance with the License Law and the Code of Ethics. And so we're not going to get too far into that today. The only thing that I would say about that specifically is that no, this is if you're going to have conditional language in an email because you're going to send an offer to purchase in 220 as two separate documents, not attached, two separate documents. If you're going to send an email with an offer that's conditioned on cooperative compensation, there won't, this something that you're going to need to talk to your BIC or your firm's lawyer about, that there won't be language, at least yet, coming from the NC Realtors. It is something that I expect the Forms Committee to look at this year. But it, right now there's not a Forms solution to that. That is not, I will just say this, the Forms Committee tried very, very hard to come up with a form solution before these changes rolled out. The issue is that, the Real Estate Commission has their rules and they have a particular way that they want them navigated. So we couldn't come up with, a forms change that accommodated all that. But I expect everyone to try again. And this is no slam on the commission. So please don't feel like I'm slamming the commission. I'm not. They have their rules and they have a way that they want them implemented. We're trying to accommodate that the best that we can and work with them through that. So just so you know, as far as like a forms solution to that scenario I just gave, yes, it was looked at. Yes, it was tried. But at the end of the day, the best that we have right now is just that if you're going to make a conditional offer, then make sure you read that Q&A, make sure it's at the written direction of your buyer client, and make sure that any email like that is it's a last resort effort. Try to work out cooperative compensation beforehand, because especially on the listing agent side, how do you know if you don't at least have a preview of what the offer terms are? Then how do you know if the cooperative compensation is actually going to be in your client's best interest? That's one of the things about, blanket compensation going away. And honestly, one of the antitrust issues that was addressed in the Burnett case or raised by the plaintiffs in that case, like the focus on your client and what's best for your client. Buyer agents should do that and listing agents should also. And one of the things that listing agents may want to do is, as far as blanket offers, that may be in your client's best interest, depending on the client and the market, and it may not be. So it's one of those things where I'm not saying there's a right or wrong answer, but tracking back to, potential conditional offers being made, it's possible to do so, but make sure that you've got written direction from your client to do that. And furthermore, that any conditional, there doesn't need to be any magic words in email or anything like that. You guys already do this in several other contexts that I'm not going to go into, but I think that, putting conditional language in email, something to the effect that, this offer, the attached offer is, contingent on seller or listing agent agreeing to cooperative compensation, also attached, something like that. It doesn't need to be magic. It just needs to be something to make it clear that the buyer's offer is conditioned on, cooperative compensation.
I want to jump on there. There's one in front of me right now that says, should 220 be noted as an addendum on the offer to purchase to make the offer contingent on the terms? 220 should be not attached to the offer to purchase. It should be not noted in the offer to purchase. It cannot be linked. And that's a real estate commission thing. So he's saying send the notes in an email, attach in a separate PDF. Should not be linked together. The compensation and the contract should not be linked.
And also, while we're on the topic, don't attach 220 to the offer. Do not put it in the MLS. If you're going to put it on your firm's website, then, that is likely going to be permissible, but I will defer to Canopy on that. That's a specific to them. If they disagree with me, that please ignore my opinion. My opinion on that is very, very unimportant compared to whatever, the staff at Canopy has to tell you on that.
I saw a question about what does it mean when a form is suspended? So essentially, it means that we know it needs edits, major edits maybe, and we didn't have time. So our committee meets August through March, April, and we all all come from across the state. So from the coast to the mountains, we drive to Greensboro. We meet from 9:30 a.m. until 1:32, 3 in the afternoon, and we hash out all the things we have to hash out. And sometimes there just isn't time. So when we made some of these major rewrites this year, we did the forms, but we didn't also have time to then go to the guidelines, for an example, and make sure the guidelines reflected those things. So instead of having an incorrect guideline still hanging out there for you guys, we suspend it, which is basically us saying, hey, don't use this right now, it's under construction. And so then that becomes something we work on the next cycle. I've also seen a lot of questions about commercial forms. We haven't really said it yet, but our committee is the North Carolina Realtors Residential Forms Committee. So we have no purview over commercial. Most of us don't even practice in commercial real estate, so we won't be having any commercial discussions today. All right, Charisma, have you seen anything else that is kind of a common theme? My head is spinning with these questions.
No, I see a few, but I think you guys addressed it. I've seen a few questions about showing instead of having them sign a buyer or just having them sign an unrepresentative as their own listing, those kind of things. If you guys just want to speak to that one more time. Without the 201 or the 203 form.
Yeah, so as a listing agent showing your own listing to an unrepresented buyer, like at an open house, my understanding is that no, you do not need an agreement with that buyer because you are not representing that buyer. You are representing the seller. So if you're representing the seller, you would not need that. If you're representing the buyer, then yes, you would need that agreement. John or Jennifer or someone with Canopy, please step in.
Some people were asking that they're not the listing agent. They just wanted to show property. So the question was, if I show property, I'm not the listing agent and it's an unrepresented buyer, do I have to have the form signed? That was a little confusing to me why you would show. I guess you want to be a seller sub agent.
Yeah, I mean, like I said, and I don't want to retread too much on stuff we've already discussed, in this presentation today. But again, on this, if you're a listing agent or a seller sub agent, mind you, if you're going to be a seller sub agent, the seller has to agree to that in writing. So there's got to be you can't just be showing a house to an unrepresented buyer as a seller sub agent unless the seller is given consent for that. So just understand that. But as a listing agent or a seller sub agent, no, you do not need a written buyer agreement. But if you are working with a buyer and intend to show them a house, then you would need a written buyer agreement. And like I said, Form 203 is a pretty good fit for that. It's basically the same as oral buyer agency. It's non-exclusive. And later, if you want to sign an exclusive agreement, you can. Again, the Q&A that came out in the Realtor Rundown yesterday goes into quite a bit of detail on that from NC Realtors.
And that's what I wanted you to cover the sub agent part of that. So if you're showing a house, you're not the listing agent, you need something signed either from the seller that authorizes you to be a sub agent or from the buyer for an agency agreement. You can't just show houses without something anymore.
That's correct. The real estate commission has been pretty clear that there's not some some gray area where there's not agency. If you're going to be showing a house, you're going to be in some kind of agency, either seller sub agency, listing agent, or buyer agent.
Right. Ladies, am I missing some?
I saw one that I can try to answer. I think this person, I just want to make sure everybody understands. So the question was, so Form 220 operating compensation goes along with the listing agreement 101 and 715 goes with the buyer. So no, 715 is for any agency agreement of any type. So any kind of listing, any kind of buyer's agency agreement, that if you do not have a brand new agency agreement signed now with the new language to bring us into compliance, then you use 715. So whether it's a listing with a seller or an agency agreement with a buyer, you need to use a 715. And then 220, the settlement, one of the provisions of the settlement is that you have to have consent from the buyer and seller. They have to be aware of what's happening. So 220 for compensation, even if compensation is from the listing agent or if it's from the seller, the buyer should be signing that. So everybody's aware of what's happening now, full disclosure, full knowledge.
I'm trying to look for common themes.
Now I'm scrolling too.
You guys have some flood disclosures that you might want to, we can discuss later and take back to the forums committee. You have a few different questions about trout buffers, properties in the county that fall in the new flood disclosures, about the way some of the flood
Yeah,
disclosures.
so that's what I was saying about in that section. They're called so many different things across. So in Mecklenburg County, we have a swim buffer. And you have undesignated flood areas, you have FEMA federal designated flood areas. We have people on the committee from the mountains all the way to the coast, and the people from the coast, when they start telling us the things that they have to do and what they're called, and creek buffers and the Army Corps of Engineer has to be involved. So there are so many different names for so many different versions of what anything near water, near a flood zone are. That's why there's another line there, so you can be more specific, because they're called different things, county to county, region to region across the state.
I just saw a question asking the seller checklist, the closing guidelines for seller. That new form is form number 170. There are any other questions, really anything not NAR
Some
settlement
people were
related?
asking questions about paying compensation directly to a buyer. I think that's not correct. Compensation, regardless of who's paying and how it's paid, should be on the
Oh my God.
settlement statement or whatever, a HUD if it's cash or a CD.
Sorry, y'all. Scrolling through questions and my mouse got a little crazy.
I think someone asked about the deadline for being in compliance. They wanted to confirm it was the August 17th date.
Someone asked the list of forms changes. I will try to find that and repost it to that specific question, but I did post that to almost one of the very first questions that was answered. So if you scroll up in the answered questions, that should be there. I'm going to try and find it, but last time I scrolled like crazy, my screen went a little nuts. I don't want to do that to you guys again. Oh, I found it. There we go.
I will say this, Canopy, there has been a lot of questions. We are taking all your questions very serious in the very near future. I can't tell you what date in the near future, but it will be very near. We will try to have a town hall to do more information to gather some of these questions and put them back out to you all for a question and answer session. There will be form changes very specific to the practice changes to help. So this will not be the last time you hear us speaking to you about this. We are going to address some of these questions at a later date. And I just want to remind everyone, August 1st, which is this Thursday, August 1st, is the deadline, just so that you remember that for Canopy, August 1st. So I know you've heard the date nationally, August 17th, but August 1st is when Canopy puts their rules into effect for the practice changes. So I just wanted to remind everyone of that. Please, before we end this Zoom, please put your questions in there. Again, I promise you, they are not being ignored. Please do. What we wanted to use this time today to explain the forms changes. Again, we will make time to address your questions. Amy, Jennifer, or John, are there any other questions you want to address before we end this session that you think need to be addressed right now?
I was scrolling through and a lot of them, it looks like we already covered. So I don't see anything in there that's too burning, at least as to forms changes in particular. Thank you very much for having me.
Thank you, John, for your time again. Thank you so much. Jennifer, do you have anything you want to address?
Just
No.
keep reading everything you can, keep following every Monday, there's a Q&A that comes out. It should be in your email box from NCR, and Dawn answers legal questions throughout the entire year. So keep following those. Canopy's put out a ton of resources. Keep following all of those. This is a big change, and I think you just have to keep educating yourself and reading as much as you can, and getting the resources that NCR is giving and the Canopy is giving us, so that you try to be as educated as you can on this, and we'll just have to see how this all falls out in the next few months.
Amy, do you have anything?
Nothing else. Thank you all for tuning in. Thank you for letting us talk with you. I know we weren't able to answer all of your questions, and I know I said in the beginning this was really not meant to be NAR settlement specific. I know that's where a lot of the questions and frustration and confusion is, but hopefully we were able to provide some guidance on form specific things. Hopefully you guys like some of the things we've done, some of the new forms we provided. And if not, the forms email is up on the screen. Again, I've gone back to that slide. Anytime you've got a forms suggestion, definitely send it to that email address. I can pretty well promise you it will get to me, and I will be able to take a peek at it. So thank you again for having me.
All right. Thank you, guys. Just remember, August 1st is our day. Remember, we're all starting at the same place together. Just show grace to everybody. We will keep bringing you updated communication through video. Please know the broker relations site is being updated probably weekly. The practice changes, everything you can think of, please bookmark it. We are here for you. We understand the fear of change, but we are all in this together. So, like I said, look out for all the communication that you will be seeing. And I want to say thank you to Jennifer, thank you to John, and thank you to Amy for participating in our forms change hot topic. Thank you so much. Everyone, have a great day.